Hey there, welcome back to yet another episode in this journey of demystifying the Patent Act. In the last episode, we selected a type of application that we intend to file. In a sense, we also provided the date of our invention. Considering the novelty and non obviousness requirement for the patentability of an invention, the date plays an important role because anything published before the priority date of our invention can be used against our invention, in a sense, to reject the patent application. Therefore, it is important to accurately identify the priority date. In this video, we will be discussing Section 11, which provides us with a set of guidelines to correctly identify the priority date. Section 11 starts by stating that every claim of an application will have one or more priority dates. But the question is, how do we identify the priority dates? Let's go to the very basic use case where an application was filed with a provisional specification, and that provisional specification was converted to a regular specification. Section 9.1. Recall Section 9.3 where a regular specification can be converted to a provisional specification within 12 months and then later converted into a regular specification again. We discussed why we need to do all that. So in these two cases, a provisional application was filed and a corresponding regular application was converted within 12 months of time frame. 9.1, 9.3. In such case, what is the priority date of the regular application? Assumption is the claim contained in the complete specification depends on the matter disclosed in the earlier filed applications, which are the provisional applications. In such a case, the priority date will be of the earliest filing date, of the earlier filed specification. Now, this is one scenario. Considering another use case where multiple provisional applications were filed and then a regular application was filed, what will be the priority in such a case? Priority will be where the subject matter was disclosed, right? Let's see the use case. Now, one of the use case could be the subject matter is depending on one of the application. Could be any one of them, P1, P2, P3, any one of them. Another one could be the subject matter is partly disclosed in all of them, P1, P2, P3. The last case could be the subject matter is completely disclosed in all of them. How do we decide the priority date in such cases? Fairly, it should be based on where the subject matter was disclosed completely, because that's where you have let out the idea to the public fully, isn't it? Let's see how the priority date is calculated in such case. So in the first case, when it was depending on one of them, the green line, the priority date would be the date of filing of that application. Fair enough. In the second case, when it was partly dependent on each one of them, in such a case, because it was partly depending on each one of them, we go to the later filed application because we think that by then everything was disclosed. So we take the priority from the last filed application. In the third case, where it was completely disclosed in all of them, the yellow case. So we disclosed it completely in the first one also, second one also, third one also. So we take the priority from the very first case. Fair enough. Let's take another use case as per section 11.4. Before this, section 7.1 says an application for a patent should be towards one invention. Claims should be connected to one inventive concept. Section 10.5. What if they are not? In such a cases, during examination, controller may object to it and may ask you to divide the application or may ask you to choose a set of claims that you would want to be in this application and choose another set of claims that you would want to file another application for. In the last episode, also we discussed about it. So a divisional application gets filed for the set of claims that we choose to file in another application. In such case, what would be the priority date? Everything was disclosed in either the regular specification or the provisional specification as per section 9. So we choose the date where it was disclosed. In such, first assumption could be it was already disclosed in the provisional. So we take the priority date of the provisional. Therefore, the priority date of the divisional application would be the priority date of the regular specification, the earlier, the original one. Yeah. Moving on, So we have identified the requirements. We need to match the requirements in terms of where was the subject matter disclosed to identify the priority date of my application. There could be scenarios where I have a claim based on the requirement where it has two or more priority dates. So one application, another application, the subject matter was disclosed here also, here also. So which date should I be taking? In such cases, I take the earliest date, the earliest priority date. There could be a case where the claim doesn't have any priority date because it doesn't match the requirements that we talked about, the subject matter disclosure requirements. In such cases, the priority date of this particular claim would be the filing date of this specification. With me so far? Amazing. Now, in section 9.4, the applicant can put a request to the controller to cancel the provisional application. What are we doing? We are literally shifting the date of the filing because provisional application is cancelled. So there is no date there. So date is here. There is another provision where if you don't want to cancel that particular date, you can shift the date. You can shift the date by maximum of 6 months. This is covered in section 17, post dating of an application. In such cases, because you have post dated the application, this will have effect on everything that we discussed earlier also. Obviously, right? If you change the date, everything else also gets changed because the initial date is changed. So with this, we have identified the priority date. Now we know what is the significance of priority date. Significance of the priority date is anything published or made available to the public after that particular date will not be considered against our invention while evaluating the patentability of our invention. Now, from the inventor's point of view also, so 11.8 says that if the applicant were also publish or start using the invention after their priority date, it will not impact the absolute novelty requirement of the patentability. So it will not make the claims invalid. You cannot question the validity of the claim based on that. Similarly, any patent application filed on the priority date or after the priority date of our claim will not have any impact on the validity of it. All in all, anything which is done on or after the priority date of our claim will not have any negative impact on the patentability requirement of our invention. Fair enough? So here is the gist. You decide the priority date of a claim based on where the subject matter was disclosed. In case the subject matter was disclosed completely in one or more of earlier filings, then we choose the earliest of the filing as the priority date. In case the subject matter was disclosed partly in one or more, then we take the latest one. So with the help of section 11, we were able to identify the priority date in an accurate manner. The priority date plays an important role in the process and procedure adopted by the patent office while examining your application or processing your application. In the next episode, we will talk about one such milestone procedure, which is publication, and how it is impacted by the priority date. So I'll see you in the next video. Till then, take care and be well.